Gil Gillette.
You haven't provided the audio recording that this committee, the chairman, requested that was due Thursday. You didn't give us an advanced copy of your opening statement, but yet there was reporting on it somewhere else. There seems to be more information from YouTube videos than you're able to provide for us, and it begs the question to anyone. You're in charge of the investigation of your own failure. So how is anybody in America supposed to be able to trust the results of that investigation as being anything transparent and genuine?
That's the last question, but please feel free to answer the question, Director.
Just dicks. Caw-caw. Titty. Sure shit.
He finally passed the driving test April 21st, 2023. And SR 22 was mailed April 13th, 2023, and it was recorded April 30th, 2023. You finally met all your requirements on May 1st of 2023.
Office and show us how to do it.
I normally can do it like that when I have them downloaded to my computer. That's why I pre-download like a million things on here. But
it's only 15 minutes. It's only 15 minutes, and
the county gave me a computer with only a 500 gigabyte hard drive. County gave me a computer with only a 500 gigabyte hard drive. County gave me a computer with only a 500 gigabyte hard drive.
Well,
Bill, I was going to ask you, do we have witnesses for this hearing?
Watson Bliss, if they are needing to testify.
I'm sorry, full names?
Eric Watts, Amy Bliss.
Just, you just set up everything you need to set up. Oh, let me mute us so that we're not telling everybody what we're. Okay, we're ready, Jill. I've got a smarter person than me in the wings, and she's going to come over and click play whenever you tell me to click play.
I think we just need to do a share screen and we can watch the video. The other argument is about his driving record. It's the only other thing.
Okay. Let's go on the record and we can announce our. Oh, I think the judge hears me. Sorry.
Wanda will go on the record. Cases filed, State of Kansas versus John Cannon, Bell County case number 23, CR 20, by Ms. Gillette, defendant in person, and by Mr. Kearns. Matter does regularly come before the court this date upon the motion of the defendant to suppress evidence. Announcements to the court at this point.
Your Honor, I've had an opportunity to talk with the prosecution. What we've agreed to do is stipulate to the admission of the traffic stop video. It's about a 15-minute video, and with the assistance of my colleague, we will be able to play that for the court, and then we have arguments with regard to suppression after that.
Thank you, Mr. Kearns. And Ms. Gillette, are you ready to proceed?
Yes, Judge, I believe we can watch the video.
Thank you, Ms. Gillette. Please proceed.
When she smiles like that, she's fucking pissed. You'll see a good example of that later when she freaks out.
With playing of the video, Mr. Kearns.
We'll do so, Your Honor.
Judge, we're going off the record for the playing of that.
Yes, off record for purposes of playing of the video.
There's sound in
Yep, she's smelling her fingers. That means she's worried because her plan got foiled. She was going to not play the video and then bring Watts and Bliss in to testify and lie like she always does.
Good. I think the sound doesn't come on until he actually gets out. She actually.
Listen to this disingenuousness.
Thank you, Holly.
Kurt, when you click share screen, there's a little like menu button for more. You have to click on it and hit share sound as well for the sound to play.
Yeah, remember when she fucked up doing that in Robert Walker's trial? What a dumbass. That is not helpful at all. She's being a bitch. I bet those sausage fingers smell like barbecue.
No, Holly.
I zoomed in like this the whole time to see if there was something that ever came up on her radar. Nothing ever pops up. You guys remember VHS tapes? Pause play, pause play, pause play. This is the equivalent of that. It was burned to DVD and then it was converted back to probably AVI or whatever extension, and then now it's playing live through a Zoom. So it's like a dub of a dub of a dub of a dub.
Did you guys share sound?
It goes on until the stop's actually done, and then the sound comes on at that point. Once the officer gets.
Damn it, JB.
I can't help it. What did I do wrong?
You're driving. Anyway. Well, actually, you were speeding. I
want to see the radar.
I tracked you at 58 miles an hour. That's 3 miles over. I have every right to be able to pull you over.
On my
and I have on my radar, I have 58. By pacing you, 58 miles an hour. And
I'm doing is going right down here to Steve Cook.
You are still driving.
And I've got all the stuff that I need.
Do you have? Can I see your valid driver's license, please? Not the letter. I need a valid driver's license. And we went through this last time, JB.
Yeah, we did.
We did. Okay. I'm going to follow you up until the next county road. I'm going to have you follow.
Right down on the county line. I've got to get down there to Steve Cook.
I'm going to follow you until the next county line. And you're going to pull over on that side.
we get these at Steve Cook right down the road.
I know, I thought the same thing, but it's not what it looks like.
You call him, he can meet us right here. I need you to turn off the vehicle, give me your keys.
You're making a huge mistake. That's a fact. Come here, roll my window, please.
I really actually expected after.
I really expected you not to fuck with me after it was over 3 miles. You followed me right up my ass.
Well, when we first turned and I seen your vehicle, no, let me finish, JB.
No,
when we first turned, I was trying to check and see your rear views to see if Cody or someone else was driving. I really expected you to not be driving after we had that conversation.
Well, you know what? Even Shirley said, well, if that's all you can do, that's all you can do. And I said, yep, that's all I can do. And she said, well, if they do it again, just have them come get, or just call me and I'll come get you.
Did a horrible job of explaining, but that was advice of a lawyer. Marianne Shirley is a lawyer, and he said Shirley said, so.
What?
Let me put those in the front seat. I will let you call Cook real quick, or was it Steve? Yeah, call Steve. I'll give you that.
He's trying to gather cows.
Leave them in the back of your truck.
You know what those are?
Well, we're not leaving. Or hand them to me. I'm not leaving until I get a backup because I'm gonna have to tow your vehicle again. Hand them to me, and I'll keep them and I'll put them in the front of my truck, my car.
You know what I just did with them? So we're not leaving until he gets here, or somebody else gets here?
Yeah, no, I can't leave. I have to stay here with the vehicle.
I don't want to.
After the conversation that we had, that I wouldn't see you.
You know what? You didn't see me until twice. Yesterday, Kim and I come down to get feed, and another cop picked me up right there at the exact same spot you did. How ironic is that shit?
You know what, JB? Not that it's any. I don't have to explain myself to you, but I was on a call, and your truck is. I was headed towards a call.
I decided to fuck me instead.
It was just to go check on things. And I seen this vehicle, and I'm like, no freaking way. And I checked your reviews. I was giving you the benefit of the doubt, checking to see if freaking Cody or somebody was else driving. Yeah. And you know what? I don't need a reason to pull you over. I can pull you over for an investigatory stop because I know this is your vehicle. And I know you don't have a valid driver's license.
Well, according to the DMV, I do.
According to we had this conversation last time. Let me see your driver's license. Fort County, Kansas, Ellen. See this right here? It says identification card. You have not gotten a valid driver's license yet. This is a ID card. You do not have a valid driver's license. King 02408612. Again, that's King 02408612.
10-4.
And I also told you last time, if you get everything squared away, have us run it.
I have been doing that.
Okay, did you have us run it? I tried to help you out. I tried. What did it come back as?
Not restricted.
Did it come back as? Does it come back as an ID only?
I don't know what it came back as.
Okay, well, we'll figure it out.
All I know is what the DMV told me twice or 3 times now, and what you guys don't care about.
It's the state system. The DMV, the state's all the state, but it's a different system. And if this does not, you have to have a valid driver's license. This is an ID only. And until you get a driver's license, whether it's the paper, then you can't drive.
According to them, I can.
4, go ahead. No, you can't.
And I can't
the DMV is not the freaking...
I did call Gary Harris, and he said he was on another job. So I did call Chautauqua County Greg Jocelyn, and he said he's 40 minutes out, but he's able to do it, and he'll be heading there now.
Great. 80 miles out of the way.
10-4. Does that Kansas OLN come back as a valid driver's license or as an ID only? I don't need the paperwork.
I'm running it right now.
Hey, I'm up here at Angus Road. They're arresting me again.
4, go ahead.
Where do you want me to put your blood to?
Where do you want? Just leaving on my rest.
I'm just right up here on it.
South of Moline on 99 on Angus.
I'll be out here in a little bit.
10-4, do you need me lights and sirens or?
Thanks.
Negative. I'm going to be here for a minute waiting on the tow truck.
10-4. County to L4, I have all that information when you're ready.
10-4. I just need to know, is it a valid driver's license or is it an ID only?
10-4, it still says state ID, and that expires in 2/3 of 2029, but it only says state ID.
10-4, if you can print that out for me.
Just go back restricted.
It comes back as ID only. It's not about the restrictions. It's not about the thing. You do not have a valid driver's license. We explained. No, you don't.
That's what that paper says.
It's not about the paper.
I'm following all.
It is not about the paper, JB. It is.
Spoiler alert. It's all about the paper. You stupid bitch.
You've got to have a valid driver's license to go with that paper.
See, that's funny because if you had a valid driver's license, you wouldn't need the paper. Dang, if only there was part of the vehicle code that said you can't arrest people with privileges reinstated.
You cannot convict someone whose privileges are reinstated.
I'm placing you under arrest. Turn around, place your hands behind your back. You have the right to remain silent. Anything you say can and will be used against you in court of law. Do you understand that? You have a right to an attorney. If you can't afford one may be appointed to you. Do you understand that? Yes. You have a right to have an attorney present when we question you. Oh, I forgot my shoulder. Apologize. At any time you can stop talking. Do you understand that? All right. Do you have any weapons or anything besides probably your knife?
Yeah, my fucking knife.
I'm gonna place this in my left front pocket. That's where I've got your
pickup, will you?
Yeah. Well, okay. All right. We explained this. I explained this to you in depth last time.
Yeah, I know.
But yet you still choose to drive.
Well, you ain't got a choice. You ain't got a choice.
Hair, just get back out. I'll put these in front. I know your shoulder's hurting. Can you get back out?
I don't know.
I don't know. This is your shoulder, bad one, right?
Yeah.
I'll put them in front. So I'm not trying not to move your arm.
Yep, some things you can't fake. He's not faking that. His shoulder hurts like a bitch right now because of her.
All front. Put it in front. Wait, hold on. I still gotta. Let me take it off and I'll put it the right way though. When'd you get out of your sling?
I ain't supposed to be out yet.
Well, then why the hell aren't you in there, you crazy head? That's just silliness too.
Well, a lot of stuff I didn't do.
That's it.
Well, look who we have here. Deputy Douchebag.
All right, that denotes the completion of the video.
I mean, I'm no chiropractor, but it looks like he has full range of motion in that upper dorsimus area.
Video stop made by the Elk County Deputy Sheriff. Rhonda will go back on the record, and the record may reflect the presence of the parties previously appearing. Ms. Gillette, you may call next witness if you do have any witnesses.
Judge, I think the witnesses are on through the Elk County Sheriff's Office is logged in, but I think that the video speaks for itself. Mr. Cannon was driving without his license again, and he had multiple cases before this one, and they knew his license was ID only card because he had not fulfilled all the requirements. It's explained in my brief in detail, and there are multiple exhibits that go with that response that we have cited to in our brief, and his certified driving record and the previous certified driving records that we pulled, which show that basically he didn't have any driver's license at the time, and he came back ID only card. His argument is a letter he got from the DMV saying he had to go do a bunch of stuff to get his driver's license was a license. And
Well, that's because it is a license, Jill.
it doesn't say that in the letter.
You're literally about to quote both KSAs that literally, in writing, tell you that it's a license.
It says you must fulfill these requirements. He is not charged with 8-262. He is charged with 8-235.
To quote a very smart person, it may not say rebuttal, but that's a rebuttal.
Not having his driver's license. 8-262 says you cannot convict someone whose privileges are reinstated. You cannot convict someone whose privileges are reinstated, and whose privileges are reinstated, but must go and do a whole bunch of things to get their license.
Can you charge somebody with a statute that says you can't charge somebody?
He's not charged with that. He's charged with 8-235, not having a license.
In my experience, every time it says you have to have something, there's always some kind of exception. You know what I'm saying? Okay, here's the one she says he's not charged with. No person shall be convicted under this section if such person was entitled at the time of arrest under KSA blah 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 and amendments thereto to return of such person's driver's license. Entitled to the return of such person's driver's license. I wonder how one would know if they were entitled to the return of their driver license. Maybe a letter that said their driving privileges are returned to them. Just guessing. I don't have a law degree, but I'm just going to do this based on the English that I know. So A says no person, and then some words, shall drive any motor vehicle upon a highway in the state unless such person has a valid driver's license. Now, those words that I skipped are except those expressly exempted. So that previous statement has exemptions. Now, on B, it says any person licensed under the Motor Vehicle Driver's License Act may exercise the privilege granted upon all streets and highways in the state and shall not be required to obtain another license to exercise such privilege by any local authority. How could you misunderstand that to be anything other than what it says?
And the letter he received is outlined in his driving record, and that says that you must do, and it has a long list of things he had to do. When the sheriff printed his driving record, and it's a certified copy of his driving record, it specifically says he failed his test. And that is in our response, that he failed his test. And the printout for April 6th, 2023 at 4:59, which is Exhibit B, is a copy of the certified driving record for J.B. Cannon, and it shows the defendant failed his driving test and did not pass on March 24th, 2023. The defendant had failed his test and knew he did not possess the right to drive. He was stopped on April 6th, 2024, just 12 days later.
Whoa, slow down, Jill. I'm not a very good mathematizer. Say those dates one more time slowly for me.
Pass on March 24th, 2023. Was stopped on April 6th, 2024, just 12 days later.
Yeah, I really suck at math. I'm coming up with like 377, maybe something like that.
And he did not have a valid license. He knew he didn't have a driver's license because he had failed his test when he went to go do it. And yet he's still out there driving and knows that he hasn't passed the requirements to have a driver's license. Just because he gets a letter that says you're finally eligible to go get one doesn't mean you have one in your possession. You
Yes, it does.
still have to pay the fees. Make sure the reinstatement is paid. Get your valid SR-22. Get your test passed. Passed both the written and physical exam. He failed it. And then he's out there driving. He was not reinstated until an SR-22 was mailed April 13th, 2023, and it was recorded April 30th, 2023. So he knew he had to do his SR-22. He knew he failed his driving test, but he's still out there driving. And when the deputy runs his record, it still comes back ID only card because he hadn't passed all of the requirements. She has every valid right to pull him over knowing he didn't have a driver's license. It got to the point that he was driving right past the deputies and had 6 cases he racked up in a very short time period because he just wouldn't stop driving.
This is so epic. This next sequence of events.
An argument, Mr. Kearns?
Your Honor, I've attached, I guess, the letter in issue to my
Keep an eye on Super Trooper Watts over here. His reaction is priceless.
brief, and I'd ask that be admitted into the record. The first sentence dated March 24th, which is a couple weeks prior to this stop that we just saw. The letter dated March 24th, 2023. The stop at issue was April 6th, 2023. The very first sentence says, and I quote, "Your driving privileges have been reinstated, period." So when I read the letter that says your driving privileges have been reinstated, period, I would ask that we go on to the next sentence. And the next sentence gives him 30 days from March 24th to complete the 4 things that counsel mentioned: pass driver's license exam, pay a reinstatement, pay an examination fee. So what we have is a March 24th date where it says you've got 30 days to get these 4 things done, but your privileges have been reinstated. Then he gets pulled over on April 6th and does his best, as you can see in the video, to kind of explain, hey, I got a letter that says your driving privileges have been reinstated. However, since you were suspended for an alcohol-related occurrence, you must complete the following requirements within 30 days of the date of that letter. That would mean that he had until April 24th, 2023.
Watch Deputy Dipshit over here on the bottom right. Whenever he realizes it's game over, it's hilarious.
Complete those 4 items. Again, this stop occurred on April 6th. So when he was pulled over on April 6th, according to the Kansas Department of Revenue Division of Vehicles, letter dated March 24th, his driving privileges have been reinstated.
Sausage fingers. Oh my God, sausage fingers. What lie am I gonna make up? I gotta lie.
So that would be our argument with regard to the first issue on the brief. The second issue on the brief that I've cited is the improper impoundment and inventory. That portion is not included in the video that we saw, but we can see where the vehicle was parked. And we can hear the officer talk about how she's got to tow it from the very beginning. But our Supreme Court has listed in State versus Sheldon the factors that are to be taken into consideration when you're lawfully impounding a vehicle. And on both of those counts, we would ask the court grant the motion to suppress.
Thank you, Mr. Kearns. The court has taken the opportunity to read the Kansas Department of Revenue Division of Vehicles, March 24, 2023 letter. As Mr. Kearns placed on the record, the statement in the first sentence is, your driving privileges have been reinstated.
I hope you're ready for this.
Subsequently, the court concurs with the argument placed before the court in regards to the issue of driver's license. Any other matters?
No, Your Honor, thank you.
So are you granting the motion to suppress of the defendant?
Yes.
Okay.
Anything for further scheduling at this point?
Well, Your Honor,
No, Your Honor,
I'll just have to file a notice of appeal because he failed his driving test and he did not have a valid license because he failed the test. That overrides that reinstatement.
I'm not disputing and not trying to argue with counsel, but for whatever reason, the Kansas Department of Revenue Divisions of Vehicles on March 24, 2023, clearly advised John Byron Cannon at 1342 10th Street, Severy, Kansas, your driving privileges.
That's what cops look like right before they arrest you. They just look at you like they're gonna fucking eat you.
Have been reinstated.
But he failed that test and did not comply with the things that he needed to do between that letter being issued and the stop. He had not.
You're right. That's a true statement. In between what he had to do, that letter, and the stop. But he had like 9 days after the stop to finish it. Okay? You get it?
Complied with all of those things, Judge. We would ask you to reconsider because he did not have it. And according to Burton, they can tow that car for any reason.
Wrong again. They can tow the car if the totality of the circumstances are reasonable when there is a totality of circumstances. And I don't think they were reasonable in this case, but whatever.
Was a case out of.
Once again, she doesn't know the words that she's saying. Nothing was overturned. The Burton one, Shelton was, the evidence was suppressed, and there's a new ruling in Burton. The new ruling said that the evidence had no business being suppressed and that they can use it, and then came up with the totality of the circumstances / reasonableness to tow. Nothing was overturned, lady. It was just a new ruling.
This Greenwood County Judicial District and was overturned and said they can tow that car for a totality of the circumstances. And that is cited in our brief. And Mr. Cannon is not charged with 8-262. He's charged with 8-235, which requires a valid license in his possession.
Wrong again. He was in possession of the one and only exemption. The one and only. the sole exemption to the having a driver's license in your possession rule. He was holding the one piece of paper that exempts him from that.
Which he did not have. This is not an 8-262 case. This is an 8-235 case, which says you have to have your valid driver's license on you.
Court stands corrected. Court stands corrected. This is a stop as to Mr. Cannon not having the license in his possession.
Really? Really? Look at his reaction. Look at this guy's reaction. So I feel bad for him.
Subsequently, the court reconsiders and does overrule and deny the suppression motion. Anything further?
No, Your Honor.
Scheduling?
Yes.
Oh.
Yes, Your Honor, we would ask for, I don't know if he's going to want a jury trial or if he's going to want a status conference.
Why don't, I'm guessing probably just a trial on stipulated facts, Jill, but how about us, if the court please, we'll take a status conference and I can talk with Jill about how we want to resolve this. If that's okay.
Okay. Court goes off record for purposes of scheduling. Chris, next available hearing date that we might have.
Okay, Judge, we could do November 12th at 1, or we could do November 13th at like 9.
Either one of those works for the defense, Your Honor.
Okay, November the 12th at 1 o'clock.
You know, Judge, can I take that back?
Yes.
Could we do the 13th at 9?
Yes.
Sorry about that.
No problem. And Rhonda will go back on the record. The record may reflect the presence of all parties previously appearing. And the court does schedule this matter for status conference November 13, 2024 at 9 a.m. November 13, 2024 at 9 a.m. And that will be by Zoom. Court continues Mr. Cannon on the bond previously posted, subject to the terms and conditions therein. There being nothing further to come before the court is in recess.
Chris, we still have that case with Mr. Ambrose, correct?
Okay, thank you.
And these are the two cats that are suing her and this judge. This dude's look on his face the whole way through is hilarious.
And Chris, I did receive that. I'll check with Jill when she comes back from the break.
I'm here.
Ah, holy shit.
I received an email over the lunch hour that there were some exhibits that you can file if they're admitted. But did you have any witness lists?
No, the exhibits are just communications between the attorneys as to delivery of drives, cost of drives.
Okay, okay, thanks.
Chris, we still have that case with Mr. Ambrose, correct?
All right, thank you.
Okay,
Okay, thanks. And Joe, while I'm thinking of it, I was going to write this down just on my paper too. I have it in my notes, but since I opened up a new case, I can't go back. Those two statute numbers you were talking about in the last case, 8-262 and 8-
County gave me a computer with only a 500 gigabyte hard drive.
Remember when she said that?
Rhonda will go ahead and go on the record. Case is entitled State of Kansas versus Jeremy Ray Austin. Help County case number 22CR58. State of Kansas appears by Help County Attorney Jill Gillette. The defendant, Mr. Austin, appears in person and by his attorney, Chase Miller. This matter does come before the court this date upon the motion of the defendant for recusal. And Mr. Miller.
Excuse me, Mr. Miller, before you start. Judge, can we have Mr. Austin mute his microphone, please?
Mr. Austin, can you hear me?
I muted it.
You might, yep, if you would. I believe we're muted. May I proceed?
Yes, please.
Thank you, Your Honor. So we have filed the motion to recuse pursuant to KSA section 20-311DA. Per that statute, it specifically states that we shall not provide the basis for it. And so we have presented that to the court, and that's where we're at.
Thank you, Mr. Miller and Ms. Gillette.
I was served the same suit, so it doesn't matter one way to me or another, Judge.
The court has had an opportunity to review the case herein. Subsequently, the court overrules and denies the defendant's motion for recusal. Anything for Mr. Miller?
Yes, Your Honor, I didn't know if the court would be comfortable today proceeding on the motion to dismiss that we had previously arranged for today's hearing.
Yes.
And if I may proceed with just very brief statements on that.
Yes.
So over the lunch hour as well, I received exhibits from the state. The indication that has been provided to us is that this DVR evidence that we have been seeking for over a year and a half now has...
A year and a half she's withheld discovery from these people. What the hell?
It's been put in the mail this morning.
And then she has the nerve to snail mail it the day of this trial, so it's still in the mail. And now listen to her excuse for why she did it. It is so bad.
This hearing was originally scheduled because we have renewed our motion to dismiss for failure to provide that discovery in a timely fashion. I have no reason to doubt that it was put in the mail this morning, but it is still not been received by my office at this time. If the court would also like to consider some other points, I have them, but I think I should defer to Ms. Gillette on that first.
Response, Ms. Gillette.
Yes, Judge, since we were here last, we were waiting on the KBI to finish the DVR download. They completed their task, and I notified Mr. Miller of that on March 7th in State's Exhibit 1, and I emailed those out so everyone would have them for today's hearing earlier today. And Under Sheriff Franks went and picked them up. And the copies are so big. They came on huge computer drives, internal computer drives. And I texted Mr. Miller March 21st as to if he wanted to buy a drive board or bring one to me, or we could sit together and watch. He said he would drop off drives to me, and I believed they were 1 terabyte because that was what was indicated on the hard drives. And then I texted again April 2nd to ask if they were going to drop off the terabyte drives. I still hadn't heard anything back on the drives. So on May 1st, I emailed Mr. Miller asking about them, and if he would leave them in Eureka, I could bring them to Elk, and let him know I texted March 25th the size. And then on April 4th, and just let me know. I still didn't get a response. So June 24th, I finally had gotten some drives sent when I emailed other individuals and Mr. Miller. And so I got an email June 24th because I had gotten them. They weren't even mailed till the end of May. This sticker, and I've saved it in my file at my Elk office, says May 27th was the day that they were stuck in the mail. And I had to purchase a drive reader, which we did and got it shipped in order to read these internal hard drives that have to be used as an external hard drive. And we started trying to copy them. But when we went to copy them, after waiting hours upon hours, and you have to dedicate one computer to it because you can't mess with the computer when it's using it, it would tell us it was too big to go on Mr. Miller's drives that he had finally brought to us. There was also some information that was not related to this case on the drives that were on there previous to us getting them that took up part of the space. So we never looked at any of that information, but it was clear that it was law office information, and pursuant to rules of evidence, when you accidentally get something that you shouldn't have, we don't open them. So we didn't open any of that and shut it down. I ended up hiring a special investigator to copy over those drives. And I let him know that his external hard drives were too small on July 15th, and that I had already paid for the cost to order them drives and what the cost would be. No money came for that. I also let them know that it ended up not wanting to copy on one of those drives and saying it was too big. So I ordered another drive that was another bigger drive. And it fit on that drive. And so we were able to get it onto 2 drives that are 2 terabytes each. And I also let him know about the suit that had been served on everyone that date. And that was on July 29th. And the data didn't fit in. I sent that July 25th. And that we thought it was going to be 23106, but I ended up actually getting it on 2 drives so that we could keep it at 154. And then he responded to me July 29th. And then I had emailed him yesterday asking him if he wanted to pick them up, email them, how he wanted to get them. And he asked me to mail them. So we mailed them. So the biggest part of all of these delays has been waiting on drives from Mr. Miller to put them on. So then I finally bought some that would work and have them made by a special investigator I had to hire that could dedicate 1 computer solely to this endeavor and make sure that they went correctly. But from March through the first part of June, all of that was waiting on Mr. Miller's drives. Once we had them, they were too small to use. And it took the KBI 3 days to be able to download them. My computers were taking days. When I contracted an outside investigator, which was Deputy Hansen, he has switched from Elk County to Greenwood County, but Sheriff Samuels gave me permission to hire him as a special investigator for this case. He had the technology to be able to do them in a day instead of taking days to do it. The KBI download took 45 days alone to get everything off the DVR onto the drives. So every time we tried to do it, it would take days. And anytime we tried to use a computer, it was screwed up. So it had to be dedicated computer. And then it would tell us it wouldn't fit. So I actually hired an outside person to make these after we waited for those drives. And I finally just bought drives that would work. And so we have sent an invoice to Mr. Miller for the cost of those drives and provided him with the information. And the special investigator took them to the post office this morning and brought me back the receipt. I have the receipt here with me if the court wants to view it, that shows that we have placed it in the U.S. mail today, addressed to them, and the expected delivery date is the 3rd. So it is gone in the mail, and it has been quite an ordeal to try to get the DVR downloaded.
If I may, Your Honor.
Mr. Miller?
Yes, we have no objection to the admissibility of the state's exhibits. I don't know if the court has those exhibits available to it at this time.
Which exhibits are you referring to, Mr. Miller?
Yes, Your Honor. I would simply be referring to State's Exhibit 1, and it would be the lower half. The statements on the right are from the state, the statements on the left are from myself. And so on March 25th, it appears as though it shows that I specifically requested the state to confirm the size of the data so that we would know what size of hard drive to send to the state, so that we would not have, a delay for sending, and I quote, a lesser insufficient drive. And the representation was made at that time that a 1 terabyte drive would be sufficient. I understand that they are in the mail, and we certainly are not trying to play games with discovery here. We've simply been trying to obtain this discovery for over a year and a half. And so I would leave it to the court's discretion on our motion to dismiss. But after the court making that determination, I would have 2 requests for clarifications, Your Honor.
This dude is slick. Did you hear that? He said, well, basically, after you do the most tyrannical thing you can possibly do and deny my motion, again, this is what I want.
But to the extent that, it was a delay on defense counsel's part in sending insufficient drives, I just simply note from the state's exhibits that we tried to be sure to send the appropriate size drives.
The drives we received already had stuff on them, so they weren't a full terabyte. They were less than a terabyte, and they didn't even get sent until May 27th, and they weren't received until June. And so we tried really hard to get them turned around really fast after we got them. But when we discovered these had stuff on them that used up part of the drive, we can't delete any privileged information off of those drives. So we had to buy new ones that were clean and had nothing on them.
Yeah, see, here's the thing, Galapagos. You didn't have to do that. You're a fucking moron. Let me show you what you could have done and avoided all this. So after you had and downloaded on your internal, external, that have to be used as internal, external hard drives, on that same computer, go to Google, type in 2 gigabyte cloud storage or Google Drive, the one that says all premium, it's a one-time thing, click on that. And if you need to, type in your credit card information. If you've already bought stuff on Google, it'll be right there. And then see that green subscribe button? You click that. And you will instantly have 2 terabytes of space. And here's the beauty of this whole plan. Since you've made them desperate and had them wait a year and a half, all you have to do is just tell them how to do this, and then they'll do it. You know what I mean? You don't even have to lift a finger other than to, log in and press a button. Of course, they would create an account, and then they would give you the password to the account. You would log in from where you're at and upload it, and then they would have it. Boom shakalaka.
We just had an opportunity to listen to the arguments, also to review the motion and the response. Subsequently, the court does overrule the defendant's motion to dismiss.
Mr. Austin and Mr. Miller may be feeling a little awkward right now, but trust me, boys, whenever the civil litigation is in effect, it's going to be a lot easier.
Further matters to come before the court. Ms. Gillette.
Your Honor, I need to know if this is going to be set for trial in October or if it's going to be set out on the calendar for status. If it's set for trial in October, we've got to get the subpoenas rolling for everyone that's going to be coming in on this matter.
And Mr. Miller?
Yes, Your Honor. I simply had 2 clarifications to request. I believe that the court had previously requested that the state file journal entries detailing our hearings here so that we can keep track of things. And I don't know that has happened. I'm not trying to engage in a tit for tat, argument about it, but I feel like it is important for documenting things. And secondarily, Your Honor, I would ask for a court determination as to whether defense motions, attempting to enforce the state's discovery obligations would be assessed against the defense or the state for the purposes of speedy trial. Given that we've spent a lot of time seeking this evidence.
First issue is in regards to unfulfilled journal entries. Is that correct, Mr. Miller?
That's correct, Your Honor. I just want a proper record.
What dates are those from?
I believe we have a journal entry filed for arraignment, which was in December. but I don't believe we have a journal entry detailing any other hearings.
Yeah, that's when you hear him say, let me check my notes. Notice Jill never does that because everything she does is just made up.
Which hearings and which dates, please?
Your Honor, I do not have them in my notes. It's simply, and if, this is not my home jurisdiction, but, for various issues, it's important, I feel like, to have documentation. And I believe that the court's previously ordered that journal entries be submitted to the court for hearings. And my request is simply that the court reiterate that.
Which dates?
Every hearing since December, Your Honor. And I don't know that we need to backfill journal entries. I'm just asking that in the future that the court reiterate its previous order that journal entries be filled out.
We had a hearing February 8th of 2024 that was on a motion and pretrial. And we had a hearing June 27th that was a control hearing status. I'm not seeing one in between there. If there was one, I can get judge's notes off of them. I believe there should probably be a journal entry from February 8th, and I don't recall if one was being processed or not. I'll have to look. But the June 27th was a status hearing with just a continuance, and we don't always do them on continuances. But if the court wants a continuance journal entry of 6/27, I am happy to do one. And the February 8th was a motions hearing. Other than that, I don't have any others on my calendar that were for this court. I have several for court in his Greenwood County cases that Ms. Shirley represents him on. And again, we don't usually do journal entries on those control hearings. We only do them on any time there's a motion or a substantial order made by the court. And I'm happy to review judges' notes and see if there's anything that requires them for 6/27/24 or 2/8/24. I don't recall whether or not there was one in between there, but I don't have any on my calendar, and I'm happy to look and see.
Any further motion for any other dates other than February 8, 2024 and June 27, 2024? Mr. Miller.
No, Your Honor, and like I stated, I don't even know that we need to backfill journal entries. I simply, if we could from this time forward record officially in a journal entry our hearings, it would be appropriate, I feel like, for issues.
Well, there being no other requests by the defense, the court does order that the state prepare an appropriate journal entry of the motion hearing on February 8, 2024. And the court does order the state to prepare a journal entry of the June 27, 2024 continuance hearing. And the court does order that Ms. Gillette prepare an appropriate journal entry from today's date.
There was a hearing, the 2/8, there was a 5:30 hearing that took the jury trial off. I don't know if it was a hearing or if we took it off the docket. We don't have very many hearings in this case during that time period. So
I do show on May 30, 2024, that the defense asked for continuance of jury trial to allow time to review and confer on discovery. There's no objection. Court granted the defense motion for continuance, set the pretrial conference plea hearing to June 27, 2024 at 9 a.m. by Zoom.
I'll do a journal.
Burkhead.
I'll do a journal entry of that continuance as well, Judge, just so we have a continuity of it.
Thank you. Anything, any other dates other than February 8, 2024, May 30, 2024, June 27, 2024, and today, August 1st, 2024, Mr. Miller?
Ooh, can I answer? Your Honor, I don't know that we need to backfill the dates just as long as we keep them in the future. Mm-hmm.
No, Your Honor, and we appreciate the court's indulgence. We simply feel like the documentation is appropriate, and that would resolve all of our remaining concerns.
Okay, Denzel, whatever. I mean, so your answer was a little better than mine, but at least I was paying attention. Did you notice how he said, I don't know that we need to backfill the dates, and they spent the next, 10 minutes backfilling dates? What a bunch of shitheads.
Any other matters to come before the court?
No, Your Honor.
At this point in time, there has not been a subsequent jury trial or pretrial conference date. Is that correct?
I believe we need to pick a pretrial conference date and jury trial date.
Thank you. Court takes recess for purposes of scheduling.
Your Honor, could I get a breakout room, please, with Mr. Miller?
Yes, Mr. Austin. Breakout room between Mr. Miller and Mr. Austin.
Thank you.
We'll be brief, Your
Yes.
Honor.
It should be ready, guys.
Thank you.
And just a reminder, Jill, if you want those exhibits from today, I don't know that they were officially admitted or anything, but if you're wanting them with the record, they need to go in the file.
Say that again for me, Rhonda.
I said the exhibits from today, I don't know that we officially admitted them, but if they are needed, they need to go and be filed with the case file.
Is it okay if I just file them under seal?
I don't know how that works down there. I just know that they're going to need to have them, and I can't just have them by email. So they need to go with the court file.
All right. I'll get a copy over to Aaron and we'll decide what to do with them or how to take care of them.
Okay.
Well. We'll just call somebody else and figure out how to get these bad boys sealed behind everybody's back and not tell anybody. Do we see a pattern here now? This chick should not be an attorney.
Sometimes they make what's called that social file that they could go into, but if they're going to be electronically recorded. Do you want those under seal, Chase? The exhibits?
Honestly, I haven't had an opportunity to review them all. I don't know that they necessarily, involve anything problematic, but
Glance at them and let me know, because I'll visit with Aaron Metter when I'm down there, the clerk, and take a copy over to her and let her decide if she wants them electronic or not.
sure. So I feel like they're just logistics for discovery. So I don't feel like it's necessary unless you feel like for some reason it would be.
Okay.
And we're still off the record, just so you know, Mr. Ward.
Yes, of course. Do we have a proposed date?
I think we're waiting for your client to get back from the breakout room. We don't.
My apologies.
Chris might have to kick him out. Then he'll be back in 60 seconds or 30 seconds, however long that takes.
Well, it's easy to hit the leave meeting as opposed to leave, breakout room button too. So.
I'm sorry, are you talking to me? I was on the phone.
We'll need dates for whether or not this is going for jury trial or status.
And
Thursday, October 17 at 9:00 for pretrial conference plea hearing. Jury trial scheduled for Tuesday, October 22nd.
Mr. Miller, are you finished with your breakout room? I still have Mr. Austin in there, but I can bring him back if you're ready.
We are finished, yes.
Okay.
And I suppose we'll wait until we have him back in here.
Okay. It'll take
not a problem.
It takes about a minute.
Okay. I appreciate it.
But I've got it in the process.
There he is. And so I apologize. I didn't catch what that October 17th date would be, Your Honor.
October 17, 2024, 9 a.m. would be for pretrial conference plea hearing. Jury trial would be scheduled for the following Tuesday, and that would be October 22nd, 9 a.m. at the Elk County Courthouse. The pretrial conference plea docket would be by Zoom.
Understood.
Okay, Rhonda, we'll go back on the record, and the record may reflect the presence of all parties previously appearing. The court does schedule this matter next before the court Thursday, October 17, 2024 at 9 a.m. for pretrial conference plea hearing. And the court schedules this matter for jury trial Tuesday, October 22nd, 2024 at 9 a.m. at the Elk County Courthouse. In the interim, the court does continue Mr. Austin on the bond previously posted, subject to the terms and conditions therein. The court does order Mr. Austin to stay in contact and communication with Mr. Miller and his bail bondsman. Keep them advised of current address, telephone number, place of employment, Mr. Austin. Further matters to come before the court. Ms. Gillette?
Not from the state, Your Honor.
Mr. Miller?
None from the defense, Your Honor. Thank you.
There being nothing further to come before the court is in recess.
We appreciate the court's time, Your Honor.
Okay, and Jill, did you get a hold of Mr. Ambrose?
Mr. Ambrose he was planning on closer to 4.
Okay.
I told him we would be ready as soon as the Austin matter was done.
Yes.
And, that I thought it might be earlier, but I don't know if he's going to be ready before 4.
Okay.
Do you want to log off and log back in, or I can just leave this sitting plugged in? It doesn't matter to me.
Let's just leave it up and we'll be ready to go, and I can watch for him.
Okay. If he gets logged on sooner, let me know.
I sure will. Thank you.
And Chris, I will actually log off because if they're not going to